The Gwart Show is sponsored by Ellipsis Labs. Ellipsis Labs is building Atlas, the blockchain purpose-built for verifiable finance. You may know of Ellipsis Labs by their first product, Phoenix, a fully on-chain order book DEX that's done over $50 billion in unincentivized volume. This is one of the strongest teams I know in crypto. If you're interested in working for a mission-driven company, Ellipsis Labs is hiring engineers who are passionate about crypto and finance to work on Atlas. You can learn more and apply on Ellipsis Labs Twitter, @ellipsis_labs. Don't forget to check out Atlas too, @AtlasXYZ on Twitter. Hey guys, today we have on Peter Van Valkenburgh from Coin Center. A lot of new stuff has come to light on the regulatory side, as you can imagine, new administration. So quite excited to have him on. We're going to talk about a few specific things. But yeah, welcome. If you want to just introduce yourself, that'd be great.
Hey, Gwart. Thanks for having me on. I do love your show. I'm Peter Van Valkenburgh. I'm the director of, that was my first mistake, actually. I'm the executive director of Coin Center. And part of the reason we wanted to do your show, Gwart, was to talk about that transition. Coin Center is a nonprofit. We're based in Washington, D.C. We've been working in this space for 10 years, just advocating for people's right to use the technology and to build in the technology. And I've been there since the beginning. I was the research director when we started in 2014. And Jerry Brito was our executive director. He sort of had the original vision and marshaled the original support for Coin Center's advocacy efforts. Jerry, we couldn't convince him to stave off retirement any longer. So Jerry's retiring as of this year. And, you know, it's January 21st when we're recording this. So I've had 20 days of introducing myself as the executive director of Coin Center. And obviously it still feels weird wearing the new clothes.
Yeah, awesome. That's quite exciting. Congratulations. So can you just give us a bit of background on Coin Center? I mean, I think you guys have been around for a while. I think most people should be, like, I would assume most listeners are more or less aware, at least of the name for sure. But what do you focus on? And if you could maybe explain where you guys try to advocate versus some other groups and like what you guys really focus on.
So when we got started in 2014, you know, it's kind of interesting. There's been all this talk lately about the Ethereum Foundation and how involved they're going to be in policy. I do not want to wade into that right now. Maybe we can talk about it a little later. But when we were starting in 2014, the Bitcoin Foundation was still a going concern. like this is ancient history. A lot of people might not even know about this.
I know, right? That completely dissolved. Go ahead.
And they were this org that tried to do core dev support and also like a milk board, like public relations thing, like, hey, use Bitcoin. And also, as a third thing, the regulatory and policy outreach to government. And, you know, again, not commenting on whether the Ethereum Foundation should get involved. It didn't work so well for the Bitcoin Foundation. I think that was a big part of that divided mission with sort of conflicts between software development and government relations was part of what made the Bitcoin Foundation ultimately not that capable of surviving. And so in 2014, it was already kind of imploding. And there were a bunch of like reasonable, smart people who were huge Bitcoin advocates at the time who thought, like, this is a disaster. We need mature people who with a good reputation who can just explain Bitcoin to a member of Congress or their staff if they ask. And it was that motivation that was the genesis of Coin Center. We were founded basically with the staff that we have today, minus Jerry, who's retiring, and Robin Weissman, who was our original Hill outreach person. She's a lobbyist. She used to work for NASDAQ and things like that. And so it was super cool that we had this tight, lean team whose only mission was to represent the technology itself. Now, at the time, that was mostly Bitcoin because that was before Ethereum launched. There were a couple other like early coin projects that were in the works. Ethereum was in the works. And we didn't want to be a Bitcoin specific org, hence the name Coin Center, but we wanted to advocate for the public goods that are ideally open blockchain networks. So there are orgs out there like the Electronic Frontier Foundation that hopefully a lot of your listeners know about, who defended like the developers of the early internet when the government would come and say, you can't publish PGP or strong encryption on the internet because it's a munitions and we don't want it getting to our enemies overseas, the EFFs would come in and say, we'll support your lawsuit. You are a scientist and you're a developer and you just want good encryption technology for the internet. We'll defend you. So the EFF was never there to represent like Google or Yahoo at the time, whoever it might have been, Microsoft, the big companies at the time. They were there to represent the public goods of the internet protocols and strong encryption protocols themselves. CoinCenter's mission is to do the same for open crypto technologies. And we still coordinate actually with the Electronic Frontier Foundation and also like the older civil liberties organizations like the ACLU. But we're able to have a focus on where crypto intersects with civil liberties, like, for example, the Tornado Cash prosecutions that we'll talk about later. And we're able to focus on financial regulatory laws like the Bank Secrecy Act or the securities laws and how they intersect with First Amendment rights to speech and Fourth Amendment rights to privacy. Whereas those older internet advocacy orgs, they did the First Amendment and Fourth Amendment intersection with, say, communications laws and copyright laws and things like that. So there's a sort of specialty there, both in law and in subject matter. The core open protocols are what we're here to defend and advocate for. And we're doing it with respect to First Amendment and Fourth Amendment rights in the U.S. usually.
Yeah. Who are the other, you mentioned a couple there, but who are the other advocacy groups out there currently? Like I know Coin Center, and then obviously in the past couple years, we've seen a lot of sort of corporate funded advocacy, right? And I'm just kind of curious, I mean, to the extent that you feel like willing to like articulate some differences, right? Like, because quick example is like, obviously I see Coinbase doing a tremendous amount of advocacy, right? But I don't know exactly like who they're involved with and what they're pushing, and maybe like how that contrasts with something that CoinCenter's doing or how it overlaps. I mean, I'm sure there's overlap, but I'm just curious, like what are some of the other advocacy groups, and like where do you guys see your kind of niche, if you will?
Yeah. You don't have to be shy asking the question, because one thing that's good about things right now is it's a big pie. Like there's a lot of work to be done. And there's also, fortunately, a fair amount of generous donors to support that work. And so like, I'm not going to be here like, those guys, don't give money to them. They suck. And I'll also say that like corporate funding for advocacy shouldn't be a bad, a bad thing.
No,
right off the bat. Like it's different. But it's and some people hear like dark corporate lobbyists, and they think like Thank You for Smoking, which is an excellent film, by the way. That actually David Sachs, Crypto Czar, was a producer on. This is weird, completely irrelevant tangent, but kind of fun. Good movie about cigarette lobbyists. So yeah, what do the other orgs look like? There are other groups that are similar to Coin Center. And the most notable one I'd point to, because they do really good work, we coordinate closely with them, is the DeFi Education Fund, which originally got its start. I think I shouldn't speak for them because I don't know all the details, but I'm pretty sure they got their start from a Uniswap grant, actually, which is hugely generous from Hayden and from the community. Although I might have just stepped in it because I don't know how much was DAO decided and all these other things, Yeah,
it came from, I mean, there's definitely like some pretty strong connection with Uniswap there. So I don't think you say anything out of bounds.
So like they do amazing work on like the core issues that we do as well. So for example, Coin Center has 4 lawsuits right now running on unlicensed money transmission, which is the new one we'll talk about later. We're suing the U.S. government for its Tornado Cash sanctions so that we can keep using Tornado Cash. We're suing on how the IRS taxes block rewards. That's a guy named Josh Jarrett, who we're supporting his lawsuit. He's a Tezos staker. And we're suing for the 6050I reporting requirements, which are, we think, unconstitutional surveillance, where every time you get $10,000 or more in crypto, you have to report the name and physical address of the person who paid you. That's like core Coin Center work. These are all issues that affect people's usage of the protocol or ability to build on the open protocols. DeFi, really important, has just brought a lawsuit along with the Blockchain Association, which is a trade association in this space, and the Texas Blockchain Council when they're suing in Texas, I'm pretty sure. And that lawsuit is about the broker designation, which is something the IRS is doing that's also bad, in addition to the 6050I reporting thing that we're suing on. wherein they'd classify like a non-custodial wallet developer as a broker for third-party tax reporting purposes if their wallet software allowed their users to like connect to smart contracts to trade on dexes and things like that. So that's a good example of another org bringing a really important lawsuit, and two actually. So that's the DeFi Education Fund, and that's also the Blockchain Association. The Blockchain Association is probably one of the best examples of a trade association in this space. So, they're not mission driven like we are per se. We have our mission. It doesn't change. People donate to us. They support our work because they like what they see us doing, but it doesn't affect which policies we advocate for. The BA is a trade association, and they have a mission, but their mission is crafted and in theory changes based on the interests of their members, which are generally large exchanges in the space, large token issuers in the space, new projects, things like that. And so, that's another important perspective because, these are the companies that are doing a lot of the hard work of building and innovating in the space, and they might want more direct control over how people talk to Congress on their behalf and things like that. So that's the value of a trade association. And the Blockchain Association is a good one. They're a good partner with us and with DeFi Education Fund. And then there's sort of, there's this new trend just recently of more coin specific like advocacy. And the best example of that is the Bitcoin Policy Institute, I'd say, the BPI.
Yeah.
And they do good work too. I've talked with one of their lead policy guys about the Tornado Cash sanctions and how, especially with the DOJ now coming after the Samurai wallet guys, it also touches the Bitcoin space. And, we're all in this together, even if we have, a different favorite magic internet money. And so that's a rough roundup of like the different orgs in the space that are all related to crypto. And then there's, of course, what I hinted at earlier, which is the old school, still very valuable defenders of internet freedom, like the Electronic Frontier Foundation and the ACLU. And those orgs, they'll be there as allies when government comes for straight up software developers, including crypto software developers. But I think, they've got a lot of important work to do with respect to the open internet, and having them become laser focused on financial regulatory laws, which is a whole subdiscipline of constitutional law, where those laws intersect with free speech and privacy, is a big lift. And, I would be missing something if I didn't just say outright that, I think those are sometimes look skeptically at crypto.
Yeah, actually,
and that's fair. There's a lot of ugliness in our space. So,
I'm curious, like, just broad strokes here, does the ACLU and like some of these other more like open internet foundations, do they agree with the general, premise of free speech and, open protocol development, open source software? Do they agree with that in the context of crypto typically, or is it sort of on a case by case basis?
So the good ones do agree. Yeah. Because when you think about how the First Amendment applies to protect innovators, if you want to publish an idea, if you want to publish it in English, if you want to publish it in C++, if you want to publish it in Solidity, it's still all just ideas embodied in some sort of speech. And if the government's saying you need to get a license before you publish that code or that speech, or not just that, maybe we're going to compel you to publish your speech or your code with some extra language in it, like a backdoor or a customer disclosure warning or other things, this is compelled speech. And so these would be unconstitutional. And so any good advocate for free speech in the internet realm or in the high tech realm would say, any prior restraint or compulsion to write software a certain way is the kind of thing we're going to fight against. And the EFF and the SCLU will usually come out and do advocacy on that. It's just that their specialty is more the intersection of the Constitution and traditional copyright and communications laws, whereas Coin Center is able to specialize on things like the Bank Secrecy Act and unlicensed money transmission and things like that.
Thanks for listening to The Gwart Show on the Blockspace Podcast Network. Subscribe to our newsletter at blockspace.media to get the show directly to your inbox. Show links, transcripts, and Bitcoin articles twice per week. Stay ahead of the conversation by visiting blockspace.media.
Okay, well then let's jump into the most recent lawsuit you guys have filed. This is, yes, like generally surrounding Tornado Cash. And well, maybe you can give us a bit of an update on the Tornado Cash situation, and then we can talk about the lawsuit.
Yeah, so we can start with Tornado Cash. So 2 years ago, maybe 2.5 actually now, the U.S. regulator for sanctions policy, which is OFAC, sanctioned the Tornado Cash smart contract addresses and the Tornado Cash project generally. And that means that Americans are banned from using it, right? And they didn't immediately say that they were sanctioning the developers of that code, which was interesting. They just said, we're sanctioning the code itself. And so we brought a lawsuit. Coinbase also very, very, in a very cool way for a corporation, right? With respect to civil liberties, also funded another lawsuit in the Fifth Circuit. And these lawsuits are about how, an ordinary person or a nonprofit like myself, like Coin Center, should be able to use those Tornado Cash smart contracts as long as we're not paying North Koreans. It doesn't matter. The North Koreans have used it for their own benefit. If we're using it for our benefit and it doesn't enrich North Koreans or doesn't enrich any sanctioned persons, it's outside of the government's statutory authority to block us from using that software. And we had positive developments in the Fifth Circuit. The Coinbase-funded lawsuit, Van Loon, they actually won at the Circuit Court of Appeals level. We're waiting for our opinion in the Sixth Circuit. It's all looking pretty good, though. Like, we think we'll end up in the space where we have a nationwide injunction on OFAC sanctioning immutable smart contracts and telling Americans they can't use them for good purposes. So what happened next in the Tornado Cash world, before those victories, but after the original sanctions, we finally saw the DOJ coming after the developers of Tornado Cash. We also saw a prosecution in the Netherlands of Alexei Pertsov. I'm not a Dutch attorney, so I'm not going to speak a lot to that. We've been coordinating with with Alexei's attorney to try and just provide better technical descriptions of how the tools work for the court there, but I'm not an expert in Dutch criminal law. In the U.S., the DOJ prosecuted Roman Storm and Roman Semenov in the Southern District of New York. And what they prosecuted them for was 3 things. The first was conspiracy to violate sanctions. And so this is the argument that they should also be responsible in some ways for North Korean usage, which is the thing that originally triggered the sanctions on the protocol. We'll set that aside. We think that that's also a bad charge, and there's good legal arguments against that, but we'll set that aside for now. They're also charged with money laundering, which is a very fact-dependent charge. And the question there is, how much did they know and knowingly assist North Korea or other criminal hackers in using their protocol? And if they took some direct effort to actually help people use it, which sometimes comes up in the context of things like sting operations in crypto. Like, if you're just selling crypto, it's typically not money laundering. But if somebody sends you an email being like, hey, I really want to buy some drugs and I need some crypto to buy some drugs, so will you transfer this dollars into crypto so I can buy some drugs? You should not sell to that person, because if you know that they're going to use it for something criminal, I guess maybe some drugs are legal, but if you know they're going to use it for something criminal, then that's where money laundering charges potentially apply. We'll set those charges aside as well in the Roman Storm, Roman Semenov case. I still think they're bad charges in many ways, but it's a whole nother can of worms to talk about them. The part of this prosecution of Roman Storm and Roman Semenov that I want to get to is the charge of unlicensed money transmission. In some ways, this is the most dangerous of the 3 charges being brought against the Romans, both for the Romans themselves, because it's a low factual bar to prove guilt, and the most dangerous for our space as a whole, because if that case goes a bad direction and Roman Storm and Semenov are held liable for unlicensed money transmission, then that sets up a precedent that anyone doing something similar in our space could also become the target of an unlicensed money transmission prosecution. So what is unlicensed money transmission? There's a lot here. So money transmitters are regulated, and they're typically like PayPal or Venmo, or in the crypto space, Coinbase, because they move, money. Sometimes it's Bitcoin, not dollars. Sometimes it's ETH, whatever, but they're still actually in control of people's money and they're moving it on their behalf. They're a trusted entity, as we would say in our space. That we don't disagree with that definition of money transmission. That's perfectly fair. And people who are in that position of trust, it's reasonable to get them to get a license before they perform that activity to make sure they're not criminals themselves and that they'll have controls in place to not lose people's money or launder a bunch of terrorist funds or something like that. Now, the thing is, though, that the Tornado Cash tool, the series of smart contracts that give you privacy on Ethereum, is not custodial. And the developers of Tornado Cash don't actually have any discretion or control over any money you put in that tool. And, we know this because we can look at the blockchain, we can look at the smart contract code itself. And so, in our opinion, and it's I think the right opinion, that's not money transmission. You're providing tools that allow other people to move their own money in ways on their own behalf. You're not accepting their money and transmitting it to other people on their behalf, which is the legal standard for money transmission. And the funny thing about this charge that the DOJ has brought against the Romans is that FinCEN, the federal regulator for money transmission registration, the person you actually have to check in with if you're doing money transmission, has said repeatedly, going back to 2014 and again in 2019, that a person who doesn't control customer funds is not a money transmitter. And so what's wild is the DOJ is bringing a really aggressive felony liability charge against somebody who the regulator had previously said doesn't need a license. And it's that problem that we're really, really concerned about, because the DOJ's theory of what is money transmission, if it's not just control over funds, is anyone who facilitates the movement of coins on chain, basically. And that definition, like AT&T and Verizon facilitate the movements of coins on chain because they relay my internet packets, right? And of course, a software dev, an Ethereum core dev, a Bitcoin core dev, let alone a wallet developer, all of these people could be potential targets, which means you give the DOJ this blunt instrument to just go and pick and choose who they want to attack in this space if they're politically motivated or otherwise motivated to do damage to our area. And so we've put an amicus brief into that Southern District of New York prosecution. We've said, here, we want to help the court. The Blockchain Association and the DeFi Education Fund also wrote really good briefs saying these charges should not stand. Unfortunately, the judge in that case didn't listen to any of us or to Roman's defense and is essentially siding with the DOJ that money transmission can be any broad category of things, and they didn't have a license, so they're doing unlicensed money transmission. In order to open up a new front in this really critical battle as to who's liable for what in all of crypto, we spoke with a bunch of developers in the space, and we said, if you have a project you're working on and you're afraid, because of course you'd be afraid, look at what's happening to Roman Storm in the Southern District of New York, come talk with us. If you think you've got a really good chance of challenging this law and you're willing to stand up and actually sue the Department of Justice, we will work with you, with your lawyers, and we'll support you financially to bring that challenge. And so that brings us to our new case. Michael Llewellyn is a really talented software developer and security auditor in the Ethereum space. He used to work for OpenZeppelin. He was looking to change things up. And one of the things he wanted to do was build for us, for Coin Center, and for others, a fundraising protocol that uses assurance contracts and dominant assurance contracts, wherein, like, if people put in a certain amount, if it reaches the target level, the funds go to the charitable organization that's raising money. And if we don't reach that level, the funds go back to the donors. Just like really good, non-custodial fundraising tool. He calls it Pharos. And when he described it to us, we were like, yeah, that's something we would totally use to do like donor matching campaigns and things to raise money for Coin Center. And yes, given the DOJ's broad theory of liability in this space, publishing that protocol, because he also wants to have a front-end website, kind of like Tornado Cash, and he also potentially wants the ability to take fees and do things privately so that there's some donor privacy elements. That is something the DOJ could easily sue you for, bring a prosecution against you for. And so if before you want to publish this protocol, you'd like to sue the government to get clarity on whether you're breaking the law, you should do that. And we're also lucky that Michael was born and raised in Fort Worth, Texas, where we will have, I think, judges who care a lot about statutory interpretation and not like giving the administration huge leeway to reinterpret the law however they want. And that in itself is also good for the chances of Michael's case, I think.
Yeah, I want to ask briefly about that. Why is this a thing in the United States where it's like highly location specific as to whether or not someone's going to interpret the law correctly? Like, it's kind of a baffling concept to somebody who's obviously not in the weeds on this. It does seem like a lot of these cases are being brought or, I guess proposed in Texas. Did he need to also, side note, did he need to be a Texas resident in order for that to be the case?
Yeah. So it's a great question. And there's a lot to unpack here. I guess the short way to say it is that there's certain, there's political economy is a thing, right? Like everyone's rational actor. Well, rational actor in the economic sense. And they're all trying to further their own interests. And that includes people outside of government, like people who want to, get wealthy starting corporations. And therefore they think, well, where's the best place to start a corporation? It's Delaware because the corporate law there is good. But it also applies to people in government. So I think it's no mistake that both the Tornado Cash developer prosecutions, Roman Storm and Roman Sevenov, and the Samurai Wallet prosecutions for unlicensed money transmission were both brought by the government in the Southern District of New York. Why? Because the courts in the Southern District of New York historically are extremely prosecutorially friendly. They like prosecutors. And they especially like financial crimes prosecutors because the Southern District of New York over the 60s, 70s, 80s, and 90s became the global financial policeman because Wall Street's there. And pretty much inevitably back then, if money was moving around the world, it was gonna take a detour, at least at one point, through New York, through Wall Street. And it's that detour, it's the fact that money was there, even if, transiently or briefly, that gives prosecutors in that district standing or the right to involve themselves in those transfers and sue whoever they think is doing something wrong with those transfers. And so a whole, if you will, cottage industry grows up of prosecutorial power and defense power in Southern District of New York, and that's where those cases typically get brought. Now, in the Tornado Cash case and the Samurai Wallet case, I should check this before saying it as a definite fact, but I'm quite sure, I know Roman Storm did not live in New York ever, and I don't think any of the Samurai Wallet developers lived in New York. And so it's not like it's a convenient forum to charge the defendant. It's just there's this claim that because there are Ethereum users in New York and Tornado Cash runs on Ethereum, we can bring the case there. Now, our case is in Fort Worth, Texas. And there's one reason for that. And that is actually where Michael Llewellyn lives. And he was raised there in Tarrant County, I think, since he was a young child. So this is not what some people would call forum shopping. Michael's bringing his case where he lives.
Got it.
It would be great if you could always pick where you bring your case, because there are going to be courts that have judges that are more interested in a narrow interpretation of Congress's laws, because that cuts off some power from the administrative state. And there are some courts that are much more interested in empowering the cops to go after whoever they want. And that is a fair way to characterize differences between, say, courts in the Fifth Circuit or the Sixth Circuit or the 11th Circuit, Southern U.S., more conservative generally, but also sort of more in the tradition of Scalia, our now past Supreme Court justice, who was all about textual interpretation. And then there are other courts that are more interested in law enforcement and stopping financial fraud and crime and things like that. And that's New York. So like many things, America is a complex political system, and there are realities. You do not want to go around and claim that you're in a forum that you don't actually live in, because the courts will rightly throw you out. You can't just be a carpetbagger, if you will, and say, well, I actually live here, so I'm going to bring the lawsuit here where I think I've got to.
But it seems like the government can do that.
Well, fortunately they can, because the government's everywhere.
Yeah,
and
so they can decide always to bring these cases in the Southern District of New York where they have some edge, if you will.
Some hook. Yeah, the hook is we found these 3 Ethereum users in Southern District of New York. Or
that's pretty pathetic.
I think they actually allege in the Tornado Cash case that they had government staff there using the tool. So like,
okay, so are those people in trouble?
well, they were using the tool pursuant to an investigation, I think. So it's like, and so no, they're not in trouble, but like, it is a way of creating standing, if you will, and that is a little insidious, but it's part of how it's played.
Okay, so I wanted to go back for a second. You said that the first case unfortunately did not go your way, and in this I forget what you said. The judge threw it out, or
so
go ahead.
Yeah. So that's not our case. That's the actual prosecution of Roman Storm and Roman Semenov.
That's the criminal case.
That's the criminal case.
Got it.
And yeah, we were pretty optimistic when so his defense, Roman Storm's defense, submitted a motion to dismiss, arguing that these charges are meritless and not well articulated in the indictment, for reasons that are similar to the reasons we're arguing that unlicensed money transmission shouldn't apply to Michael Luella. And unfortunately, so we submitted amicus briefs and we said these are the reasons. FinCEN said in 2019 that this stuff doesn't require registration, so why are you going after them for failure to register? The judge said, in ruling on this motion to dismiss, she said, no, I'm going to deny the motion to dismiss. We're going to go to trial. We're going to continue on. And she gave a justification of why she's denying the motion to dismiss. It was an oral justification rather than a written one, although the transcript's now available. But that was a whole headache in itself, just getting a written copy of what she said for a number of months after she said it. She said, look, money transmission as defined in the criminal code, the thing that actually you're on the hook for with felony liability, is a broader definition than the regulator's definition of money transmission in the Bank Secrecy Act and the associated regulations that FinCEN has issued. And so, we can try and sort of like contort ourselves to imagine why the criminal definition of unlicensed money transmission would be different than the definition of who needs to get a license from the regulator. But no matter what, the situation here is really bad for not just for like software developers and the Romans, but just for the rule of law in general. Like, as a basic principle, if the government's going to hold people accountable for certain behavior and say, you will go to jail for this behavior, the government should say it up front and say it clearly so an ordinary person knows where they're allowed to walk and where they're not allowed to walk. Because if they accidentally walk into a place that they weren't allowed to walk, but you never told them that, you really can't justify throwing them in jail. Right. And so this is a basic due process concept, which is one of the three counts that Michael Llewellyn is bringing against the DOJ. The first is the statute doesn't apply to my activity, and I'd like you to say that clearly, Judge. Money transmission licensing isn't something I need to do. The second is everything I want to do in publishing the Pharos protocol, which is the crowdfunding protocol that Michael wants to build, is speech. And if you're going to say that I need to get a license for that, if you say that the law does apply to me, then that is unconstitutional under the First Amendment because it's a prior restraint on my ability to publish this code. And third, if you say that the law applies to me, there's a massive due process concern here because everyone in government up until now, up until the Roman prosecution, has said it doesn't apply to me. And so clearly there's political activity going on here where some branches of government are saying that you do this and you're committing a crime, and other branches are saying that you're not. And not only is it unclear what the law is, the government statements are directly contradictory as to what the law is. So it's wrong to hold me or anyone else criminally liable for this conduct that has been completely undescribed by the government sufficiently as illegal.
Yeah, that makes sense. I wanted to ask, in terms of going back to the criminal case for a second, you said that there's three charges. The one you're focusing on primarily here is the money transmitting aspect. Those other two, do you feel optimistic about those? Do you feel optimistic about the case in aggregate, or are there reasons to believe that, okay, maybe the money transmitter one, you guys have a case, Coinbase has a case, you push this through kind of the civil liberty side. Is there another aspect to it on those other two where it's more cumbersome? Like, what is the difference there?
Yeah. Yeah, I know this is all like a lot. We need like a flow chart or something.
It's fine. Yeah, I know. It's like quite dense for me too, because I just am,
Yeah,
spitballing. But
just one point of clarification. You said Coinbase has a case. Coinbase has a case, and we have a case challenging the sanctions. So trying to fight for Americans' rights to use Tornado Cash. Coinbase is not, as of yet, sponsoring or bringing itself a challenge to the DOJ on the unlicensed money transmission prosecutions.
Okay.
So Coin Center v. Yellen and Van Loon v. Yellen are the cases that say Americans should be able to use Tornado Cash. And that's us, and that's Coinbase supporting some of their developers. Llewellyn v. Garland is our we're supporting Michael in challenging the DOJ on its theory of unlicensed money transmission. And US v. Storm and Semenov is the criminal prosecution for unlicensed money transmission in the Southern District of New York. And we've also mentioned, if you're at home drawing the flowchart right now, we've also mentioned US v. Rodriguez, which is the criminal prosecution of the Samurai Wallet developers, also in Southern District of New York for unlicensed money transmission. And as far as those other charges within US v. Storm, the criminal prosecution of the Tornado Cash developers, yes, there's the unlicensed money transmission charge. And if Michael wins in Texas, it sets up a judicial split, if you will, between the way the New York courts are interpreting it and the way the Texas courts are interpreting it. And it can also just apply pressure to the DOJ to get them to take a more reasonable approach towards those criminal prosecutions, hopefully. On the other two charges for Roman Storm and Semenov in the Southern District of New York, you've got conspiracy to violate sanctions, the argument that they, by building the Tornado Cash tool, intended to help North Korea, a sanctioned country, move funds, which is a sanctioned thing. Americans aren't supposed to help North Korea. That's what sanctions are all about. And the money laundering charge, which is that they knowingly assisted criminals or sanctioned parties to, hide the origin of funds on chain. And so those two charges are different. How do I, what I don't want to, there's a couple things I don't want to do. There's a trial coming up in that case. And, we've been coordinating for a while now with Roman's defense team. I don't want to prejudice anyone as to their arguments in that defense. I think there are really strong arguments. What makes me angry, frankly, and sad is that a lot of the strongest legal arguments in that case were made in the motion to dismiss, and the judge just kind of ignored them, frankly, I think. She just sided with the government on all counts. And so when it goes to trial, and this is the way the criminal justice system works, the trial's all about the facts. It's not about the legal arguments per se. It's like, all right, the law says X. Now at trial, we'll let a jury decide whether you did X. But once you've already had motions and denials of motions on the law, all you can do is argue about the facts. So there's still a good chance for the Romans in the Southern District of New York that they can argue the facts persuasively and that they can ultimately appeal the legal decisions that have already been made in the motion to dismiss. But it's going to be hard. And when Judge Fela, who's the judge in that case, ruled on the motion to dismiss and said, we're rejecting your legal arguments, that's when Coin Center got really serious about the need to, on multiple fronts in Congress, working with members of Congress who don't like these prosecutions, in the incoming administration, and in the courts by finding somebody who's willing to stand up for his right to publish software. That's when we got really involved.
Yeah. Okay. That makes sense. Can you quickly clarify just maybe the difference, at least from your perspective, in this Samurai case versus the Tornado case? My interpretation is maybe that the Samurai case, because of the way mixers work, could possibly have been, it could appear more custodial for a brief moment, versus an ossified smart contract. Is that correct?
Yeah.
Or what is your read on like what at least the counter? I mean, not to be a bootlicker here, but like what is the counter argument, right?
Please, Gwart. It was just a statist.
I know, right? Like what is the kind of what are the distinctions here?
So
and similarities, sorry.
Yeah, here's what I'd say. The first thing I say to a lot of people in this space is I want to convince people who aren't already on our side, right, that these prosecutions are off base. The first thing I'd say is this. The government has two ways to charge people for the crimes that they're trying to stop right here, right? What the government's trying to do, if we think they're acting in good faith, and I think there's reasons to think they're acting in good faith. Maybe they're confused about some things, but they're acting in good faith. They're trying to stop criminals from getting the benefit of the financial system, right? And there are two ways to stop criminals from getting the benefit of this financial system. You can charge people with money laundering. The government needs to prove for money laundering that the funds that you're dealing with, they are the proceeds of criminal activities, and they need to prove that you took some substantial steps to hide the origin of those funds, right? You did something, and that something should be more than just published software, right? But what's important about the money laundering charge is you have to prove knowledge and intent that somebody actually wanted to help a criminal or help North Korea. And that's the right way for the police to go after people in this space who are actually helping criminals in North Korea, right? Now, the other charge for both the Samurai Wallet case and the Tornado Cash case is unlicensed money transmission. And this is a charge that doesn't say that you knew that you were laundering money. It says you were doing money transmission and you didn't have a license.
Got it. Yeah.
And so it doesn't even ask whether you had sort of criminal intent, whether you knew you were doing bad things in the world. It just says, were you moving money for people and did you not have a license? And so it's in many ways a strict liability criminal statute rather than one that tries to prove that someone was actually mentally culpable for the bad behavior. And so that's already a statute I think we should be really careful about bringing prosecutions, because you're going to sweep up a lot of innocent people who didn't mean to do bad things. And then the other thing I'd say is, if you're going to bring an unlicensed money transmission charge, you better be damn sure that the person was actually doing money transmission as it has been defined by regulators in the past. Because otherwise, you're just going to be surprising innocent people with a new interpretation of what they were supposed to get a license for, and they have no idea what the hell you're talking about. So it becomes a blunt instrument to go after people. Now, as far as what is money transmission in Tornado Cash versus Samurai Wallet, I think the right thing to do is to look at the FinCEN guidance from 2019, which is a comprehensive document where the regulator says, when you do this, you need to register. When you do this, you don't. And in that document, they say people who need to register are people who have total independent control over customer funds. And also, by the way, they also have this whole other section about anonymizing service providers and anonymizing software providers. And anonymizing software providers, because they do not have control over customer funds, FinCEN says, do not need to get registered and to be licensed as money transmitters. And so I don't think, if you look at the FinCEN guidance, there is a difference in the factual patterns presented by the Tornado Cash smart contracts and the Samurai Wallet coordinating server. The coordinating server is just this piece of software on the internet.
They can't rug you either, I don't think.
They can't rug you. That's that's the point. That should be the test, is whether they can walk away with the money. Because if they can walk away with the money, then they're money transmitting.
Right.
If all they've done is provide infrastructure that other people use to transmit money, and that infrastructure is software primarily, and maybe servers to maintain that software publicly on the internet, then I don't think that is at all like money transmission as defined by FinCEN.
When I hear this, right, obviously I'm biased. We have to, like, in some context, admit that we have like our biases toward this, right? Maybe it's because we think we understand the tech much better, but like obviously we have an angle here. When I hear this, I'm like, this seems like very obvious to me, right? Like it seems like this is writing this software, right? Like should be like clearly some version of free speech or whatever. If this does not end up going the way, apart from the like numerous negative externalities and like all the people that can get swept under the rug here, like you were saying, what would be a reason that this would not turn out the way that like this entire industry and like I would hope a lot of, sort of people who believe in civil liberties would want, right? Like what in your mind, what would be the most not valid, but what would be the most compelling reason that this doesn't turn out the way that we're hoping?
Yeah. I mean, I can even try and steelman the other side, right? Because we should be able to pass the ideological Turing
That's
test.
kind of what I'm looking for. Yeah.
We should be able to like, okay, here's what the DOJ is doing if they're acting in good faith here and why maybe they're right. The steelman case for these prosecutions starts with the fact that North Korea has gotten the benefit of these tools like tremendously. Like, let's just be honest. They developed a surprisingly effective team of, counterintelligence and intelligence operatives who are able to hack DeFi protocols. Now, Gwart, you might say, well, those DeFi protocols are mostly horribly specified, and so maybe they're not that much of a crack team. But the bottom line is the Ronin bridge hack and things like that brought in a lot of money to North Korea. And North Korea is going to use that money to do really bad things in the world, right? Develop nuclear weapons, other things like that. And so the steelman argument for these prosecutions is we need to use every tool we got in the toolbox to put a damper on these tools being available to our enemies like North Korea, if only to prevent nuclear war, right? And that's a strong argument. And it's also a sort of brutal argument. It's one that says a certain amount of collateral damage in this space is acceptable to stop North Korea from having the benefit of these technologies. Now, that's the best I can do for steel manning it. But I think that's persuasive to a lot of people in government. Now, the counter argument to that strong argument is twofold. One, in an American system where we prize free speech and the rule of law, you don't do that. You don't go after software developers for making tools available. The best response to there being bad speech out there, tools that North Korea can use, is more speech. Like, we should be building these tools in America so that we have a better idea of how they work and how they can be bent to our will in the long run. How can they be used by national security to promote national security interests? And the second argument is, setting aside the First Amendment of the Constitution, we should also, ask whether we could actually stop the Lazarus Group from using these tools. You're gonna take a really aggressive approach. There's gonna be collateral damage, like innocent developers in jail. Like, Americans can't use sophisticated tools, but maybe that's okay because we'll also deny North Korea access to them. That's not actually what's happening. The Tornado Cash sanctions are announced. Usage of Tornado Cash drops off for a period and then ticks right back up. The sanctions don't have any ability to stop North Koreans from using the tools. They don't even have any ability to stop Germans from using the tools. Like, that's not how extraterritorial jurisdiction works. All the sanctions can do is stop Americans from using these tools. And all prosecutions of Americans for developing these tools will do is chill First Amendment protected innovation in this country. Because, the person who wants to build the next cool thing as far as censorship resistant private money, which is important for national security because it's going to get built somewhere, is not going to build in the US because they're going to be afraid that they're going to end up in jail.
I don't find the steelman on the other side that compelling, also because they have to get this money off chain, right? Like, they ultimately, so yeah, I mean, I don't know. Like, it doesn't make a lot of logical sense to me, but again, I will concede that I obviously have somewhat.
and when you make a great point about the on ramps and off ramps, and when we've talked to folks at the DOJ who aren't involved with the prosecution, and when we've talked to folks at the FBI, and when we've talked to folks in the world of the consultant groups and the contractors, all those law enforcement people work with, like Chainalysis and Elliptic, the vast majority of really smart people who are dedicated to national security will say, yeah, the best bang for our buck is making sure that Binance is KYCing the customers that it holds money for, and making sure that Coinbase is doing that, and shutting down Garantex and the rogue custodial exchanges that are based in Russia, which is where people ultimately go and get the benefit of their crypto hacks in rubles or dollars or whatever.
Got it,
And
yeah.
so like that is the right approach. And that's the approach we were taking as a country up until really the middle of the Biden administration, when there suddenly was also this big push to go after software developers and decentralized exchanges and things that there may be arguments that we could steelman to say why this could help public policy, but there are really strong arguments on the other side saying it's not an effective way to stop criminal funds, and it's an insult to the First Amendment.
Yeah, I think like Chainalysis gets stuff wrong all the time. Like just recently, they got something very, very wrong. I read about. I'm not asking you to comment on Chainalysis, but
well, my whole point was actually defending them. Is that usually when they go in and they lobby about policy, when I've been in the same room as them, they don't ask for government to have authority to regulate immutable smart contracts or things like that. They're like, no, like we got to focus on the custodial intermediaries who have the ability to block and stop transactions before they off ramp onto fiat rails.
Yeah, but they're like some of what Chainalysis puts out is used in court cases. To my understanding, yeah. Okay, yeah. So to my understanding, and that.
Well, we're probably wading into some questionable.
Yeah,
waters.
It's okay.
No. But the one thing I would say is, well, of course, Chainalysis data is going to be used in prosecutions. It's just data that's out there. I don't. Right. I don't know. I have no knowledge of Chainalysis going out there and telling the DOJ to like prosecute these people based on our data.
Yeah, that's fair.
Data, right? You know,
that's fair. Yeah. Okay, I wanted to ask you another question. Does the fact that Tornado Cash have a token change anything?
It makes it. It changes a few things. It makes it really hard to explain to a judge what's going on, right? Because if you had a really simple case where, somebody's just published some software and somebody else is using it to move money around, that's already a hard thing to explain to a judge, because you have to explain to a judge that now software can autonomously move money. And then the prosecution or the other side, so in Llewellyn's case, we're suing the government, so they're the defense, right? Is going to come back and say, well, yeah, but what about all this crypto economics? What about the fact that they are enriched by the activity on chain in some convoluted way? Doesn't the fact that they make money off of it show that they're doing it as a business? And every money transmitter I've ever heard that does it as a business before is a money transmitter that needs to get licensed. So why does this business not need to get licensed? And you see, what I just did there might sound a little convincing to somebody who's trying to get up to speed on this tech, but I did something sneaky. Like I said, every money transmitter that does this as a business and gets ripped should get licensed. There's still the question of whether they're a money transmitter.
Right.
Like you can be a highly profitable software developer. Like Microsoft is a highly profitable software developer. They like make Windows. They make a bunch of really important software tools, but they don't move people's money. They make tools that people like. I use my Windows computer sometimes to initiate a Zelle transfer. Is that money transfer? No, of course that's not money transmission. So the existence of a Tornado Cash token in that case is what the prosecution will use in all its pleadings and has used in its pleadings to show, look how rich these guys got off of this bad thing that they're doing, as a way of sort of showing the judge, like, you should just hold them liable for unlicensed money transmission. But the fact that you made money off of an activity doesn't make the activity money transmission.
Yeah, 100%.
You did was publish software and made money off of that, that's still not money transmission.
Well, let me ask you this. Would your case and all of these cases surrounding Tornado Cash, would they be, in your opinion, much easier for you if there was not a token involved?
I'm going to qualify what I'm about to say in a second. The first thing I'd say is no. It doesn't make them per se. It shouldn't make them harder, because I don't think you should be prohibited from earning a living in order to be free of criminal law, right? Like, and if what you're doing is software development and you really don't have custody of people's funds, then you should be able to make money off of it. Now, maybe you make money off of fees instead of some sort of token thing, but I'll lump those two together as you just wanted some sort of monetization strategy for your software development. That should not change whether you're a money transmitter or not. And in fact, in Michael Llewellyn's lawsuit that we're supporting, he's in his complaint, he's saying, I'm going to lay out the facts of what I've been building and what I want to publish that I'm not publishing because I'm scared of your prosecutions. One of them is that he wants to take fees. There's no token associated with Pharos, last I checked with Michael. But he does want to have the ability to sort of have a factory contract like Uniswap and have the ability to take fees for moving out of the factory contract to individual fundraising contracts. And I'm glad he wants to include that in the facts of what he wants to build, because that helps us test this basic premise, which is software development is not money transmission, even if you're going to get money off of it, even if you're going to make money off of your software development. Now, I said I was going to qualify what I was saying with one, further thing. The rampant tokenization and new token economies in especially Ethereum, but also now Solana, and hell, if Bitcoin ever has more computational layers built on top, it'll happen in Bitcoin too. Ordinals, to some extent, it already is happening. It is tricky from a securities law standpoint.
Yeah. Well, I wanted to ask one other thing. You said you guys are very focused on the money transmitter aspect, and in the criminal case in New York, there's 3 charges. One of those is the money transmitting aspect, and that's like what you and Coinbase and all those other suits you were talking about are sort of honing in on. The other 2 charges, does the token apply more there in the sense that, again, I don't want to ask this. I'm always reluctant to ask this on the grounds that it sounds very bootlicking, but I've always been curious about this, right, myself. And if you are profiting more as a function of North Korea or state actors using this, then you may be incentivized. And again, I've been very conscious with my words here, but more incentivized to pump a token or extract a certain amount of fees versus putting a piece of ossified software out there for anybody to use. And you once it's out there, you earn nothing from it. And for all intents and purposes, you can be anonymous and you're completely extricated from the project.
So Gwart, I'd say a few things. I'd say you're definitely right about securities laws prosecutions, because those are prosecutions that are actually aimed at going after bad actors who are promising massive returns, even implicitly, maybe not explicitly. And then, people are aping in and then they're cashing out and then it's a pump and dump scheme. And that is pretty firmly securities fraud, And so, yes, that kind of behavior and that kind of activity is a real legal liability, especially for securities fraud prosecutions. And I think that'll be true even under Trump. We haven't gotten to the new administration yet, but Biden's SEC was famously aggressive, including going after good faith actors who were trying to comply, bigger companies in the space who were just trying to limit the number of tokens they list, but list things that are obviously not securities. I think under Trump, we see a general lessening of that aggression from the SEC, but I do think they might still go after fraud. I think they should. I think that's the right thing to do in this space, is clean up the bad actors and leave the compliant parties to do what they're going to do. Now, Roman Storm and Roman Semenov are not being charged with any securities fraud violations. And so the other charges, apart from unlicensed money transmission, don't have to do with token issuance any more than the unlicensed money transmission charge has to do with token issuance. The only way the token issuance and the fact that there was a DAO and things like that enters into those counts is, again, on this question of doing something as a nonprofit is different sometimes in the law than doing something as a for-profit. But it doesn't change what it is you're doing. So to prove money laundering, knowing that you made money off of money laundering is going to make it easier for a jury to convict you. But you still had to actually know that the funds were criminal, and you still had to actually take substantial steps to move the funds. And the other charge, sanctions evasion, again, knowing that you made money off of the sanctions evasion might make it easier to prove to a jury that you should be held liable for helping people evade sanctions. But you still have to prove that you wanted North Korea to use this tool and you actually deliberately assisted them in using this tool to evade sanctions laws. And the interesting thing about the sanctions charge, actually, and this was actually in the amicus brief that we wrote, is that sanctions laws exclude from the president's jurisdiction the ability to block transactions and information, including potentially very valuable transactions and information. So, just because you're making, again, just like the software development thing, just because you're making money off of it doesn't mean that the First Amendment doesn't protect you, doesn't mean that you're more likely to be guilty of a crime in some situations. You could, if you found an Iranian author who's actually a member of the government of Iran, so definitely a sanctioned person, and they publish like a romance novel, like Saddam Hussein used to write romance novels. He's from Iraq, not Iran, but and you become the American publisher of this Iranian romance novel, and you make a ton of money, and so does this government official in Iran, you might get prosecuted, but you should be found innocent because the Berman Amendments, which are a part of the sanctions laws, carve out transactions for information, even valuable transactions information like licensing sporting events in Cuba and things like this, from the purview of American sanctions. So this is all like a very legal-esque, hopefully interesting roundabout way of answering the question.
I mean, the main reason I asked is because I do know when I've read like some of the charges or some of the writing around this, they do mention the torn token, fairly often. This has gone back like since the beginning. So I just wanted to get an understanding of like what impact that really has. And it, like what you were saying, like it is.
And some of this is also the way that you prosecute things and defend against things. Crimes have elements, right? There are multiple elements to a crime. Like murder is the intentional killing of another human being with different levels of like first degree, second degree, for different levels of mental state when you do this. Money transmission licensing law has multiple elements. One of them, we're arguing, and I think we're very right on this, is that you actually accept and therefore have control over somebody else's money.
Yeah.
Another element is that you're engaged as a business in that activity. So when the government prosecutes someone, they have to prove that you had the money and were moving it for someone else, but also that you were doing it as a business. You weren't just like Uncle Joe, who's not Joe Biden, like your actual Uncle Joe. Your Uncle Joe who's going to like lend you some money and expects you to repay him in a couple of weeks. That's for family purposes, not for business purposes. So the government does have to prove that they're doing it as a business. And it would be easier to disprove that, I think, if all you did was publish immutable software to the Ethereum blockchain that doesn't create any revenue stream for you and then walk away. Yes.
Yeah. If like, so wait, let me give you just one last little hypothetical here. Yeah. Let's say that there was a completely anonymous developer who was extremely good OPSEC and launched Tornado, ossified, smart contract, no token, zero connection apart from whatever type of, NSA level stuff they can try to do. But let's just assume that like this person has like Satoshi level, ability to anonymize himself. What does the United States government do in this scenario when they see North Korea now using this tool that it can't be attributed to anybody apart from, an Ethereum address?
It would still try and block Americans from using the tool, which is why we're bringing these lawsuits to say you can't use the sanctions powers to identify software that doesn't actually directly enrich any sanctioned person.
Yeah.
So they would try that. If they found and then tried to come after the developer, I mean, good luck, man. Like, because if like that developer is going to get a lot of support from organizations like Coin Center and from the Electronic Frontier Foundation and the ACLU, because literally all they did was publish code to the Ethereum blockchain.
Yeah.
And the First Amendment arguments for that being a protected activity, I think are strong, right? Like this person isn't making money off of it. All they did was come up with an idea and publish it to a place where they can publish information. That is what a blockchain is, right? Yes, people are going to use it. Yes, it's going to have collateral consequences in the world. But that's true of blueprints too. Like when they get built, they have
Yeah.
collateral consequences. We don't tell architects that they're not allowed to publish certain blueprints. We even let people publish like recipes for making fertilizer bombs. Like I haven't read the Anarchist Cookbook.
3D printed guns on
3D printing. Like this is just the way we are as America. Not because we really want people to go out there and publish information about dangerous things, but because we know that the alternative, having a government bureau of deciding what's too dangerous to publish, is actually far more dangerous than all those people publishing those dangerous things. So yes, you'd have really strong First Amendment arguments there. But I want to come. I'm still going to come back to this. That shouldn't be the only way that you can invent and build and publish these tools. The First Amendment protects speakers who are very wealthy because of their speaking activities. The New York Times is a profitable business. Well, it used to be anyway. And New York Times versus Sullivan, one of the preeminent First Amendment cases, is about their right to run that business profitably because what they're doing is speech, not something else that requires regulation or control. And so, if you actually look at recent cases, it's amazing what the Supreme Court justices rightly stand up for in the realm of corporate and highly profitable speech. There's this case called IMS Health versus Sorrell, where Massachusetts and Vermont tried to ban people from buying and reselling prescription data, like which doctors are prescribing which medications. It's just a big data company. And Massachusetts said, you can't sell that to marketers because they're going to use that to push drugs on people. And the prescription marketing companies sued and went all the way up to the Supreme Court. And the Supreme Court said, a ban on buying and selling data is a First Amendment prior restraint. And it's not just a prior restraint in general. It's one based on a person's viewpoint, like them being a marketer for a corporation. And so it's strict scrutiny, unconstitutional to have those bans. So the Supreme Court stands up for speech, even speech that we would say is kind of questionably for the good of society, right? Because it's big pharma. But that's still the right approach. We shouldn't be in the business of deciding whose speech is valuable and whose isn't. Yeah.
So you said like very early on that you're generally quite optimistic about the prognosis of all of this, right? And
I'm optimistic that we're right on the law.
Right. Okay. So
whether courts and judges vindicate those rights, that's what we fight for, right?
Right. So my question is this. Okay. Yeah. So maybe that kind of answered it. You're optimistic about the rule of law. I was just kind of interested to know maybe like then like how do you see this ultimately playing out, and also maybe like what is the timeline on some of these like big issues, right?
In some ways, the timeline's long because these things wind their way through court. I think Roman Storm's trial has been pushed off a couple times, which is good actually, because it's the defense that wanted more time to prepare. I think right now they're gonna have their trial in April, but I might be off by a month or two. Our lawsuit that Michael Llewellyn's lawsuit that he's bringing in Texas, that's going to wind its way through court. There's not as much fact finding there because, he's already stated the things he wants to do, which are the relevant facts, and the things he feels like he's precluded from doing under the law. So that might move a little bit faster. Like again, though, still spring because the tornado cash prosecution has been going on since last year. We'll start to get more legal reasoning on this, but I think it's very likely, it's certainly possible that the Romans lose their case, or Roman Storm loses his case at trial and is found guilty of something. It's possible. It's possible he gets out. And then the right thing to do there, because I don't think those charges are all bona fide, is that they appeal, and that's another process. So, this is going to drag on for a year, 2 years, 3 years on a lot of these important topics. Also true of our sanctions lawsuits. Like we have a win in the Fifth Circuit. We're probably going to get a win, hopefully, in the Sixth Circuit, but it could be appealed by the government up to the Supreme Court, or it could be appealed to have en banc review where more judges from those circuits opine on the original decision from the smaller group of judges. So there's still things that could happen there as well as to whether Americans can use tornado cash. All of this is going to shuffle out within the next, I'd say, 2 years. And the thing that maybe accelerates the timeline as far as figuring this all out might be the Trump administration. And that's a huge question mark. We're recording this, as I said earlier, the day after Trump was inaugurated. The Biden administration was, I think it's undeniable, really aggressive in bringing these prosecutions, in the OFAC sanctions, and the way they then defended those sanctions. They could have said, no, we're only sanctioning the non-immutable smart contracts. You're right. And then backed off. But they didn't. They fought us. They said, no, we're sanctioning it all, and we'll see you in court. Maybe, and this is a huge maybe, Trump has said he wants to be pro-crypto. He wants America to be pro-crypto. Trump has Elon Musk influencing some of his decision-making here. Elon is ostensibly very pro-free speech, with X and things like that. These are huge, woolly topics. I don't mean to be, just saying it's all good now. I'm not saying that at all. There is some reason to think that, maybe this administration is interested in being pro-free speech and pro-crypto. And if that's true, then they need to come out and say that the DOJ unlicensed money transmission prosecutions are off base. They need to say that, as a general matter, we should only be prosecuting people who have control of funds. And if that's not what they say, then they should have FinCEN write new guidance saying that actually it's more people than that, just so that the rule of law is clear. But they should drop the prosecutions that were based on the old confusing rule of law. And then we'll fight over the new rule of law of the thing. But so there's some reason maybe for optimism, just because we have a changing of a guard and a new opportunity. But I still think it's going to take a long time, and it's going to be a lot of hard legal battles to actually get the law right here.
Well, we covered a lot. It was quite dense. Where can people find you, obviously? And also, if you want to, shill, you're more than welcome. It's a nonprofit. People should feel quite good about this, right?
Yeah.
How can people get involved? I'm always, maybe I'll ask one last question. I'm always curious. People say call your state representative. I don't know, this applies so much to what we're talking about here, but what are things that you think actually make, some difference?
Well, on Congress, we are working with some of our champions like Tom Emmer, the majority whip in the House, Cynthia Lummis, a powerful senator, with regards to crypto policy. These people have spoken out about the Tornado Cash prosecutions, and some of them have drafted bills. Tom Emmer's drafted a bill that would clearly create a safe harbor for non-custodial developers. So it's interesting. There may be a time where we want you to call your congressman. And I'd say stay tuned to coincenter.org, which is our website. Sign up for our newsletter, and we'll help you know when your voice will actually have an impact. Also, if you happen to live in the district of somebody in Congress and you feel strongly about this stuff, come talk to us, and we'll talk to you about whether your member has been standing up for what's right. And then, they're usually happy to meet with you. And that can be a good way to get Congress more involved in these things in a positive way. Just in general, though, this is CoinCenter's mission. This is what we do, and figuring out the most efficient way to actually lobby government or bring lawsuits that will actually promote civil liberties and meaningful change. That's hopefully our expertise, and I think we're pretty good at it. So visit coincenter.org, sign up for our newsletter, and if you like the work that you see we're doing, we would of course appreciate a donation. We take Bitcoin, we take ETH, we take a number of other cryptocurrencies. You don't have to dox yourself when you donate. In fact, on our website, there's a button that says dox myself because I want a gift. You get a t-shirt and stuff like that, or don't dox myself. And then you'll just get a naked address that you can send to. We had standing to challenge the Tornado Cash sanctions because people donated to us using Tornado Cash to protect their privacy. So CoinCenter directly benefited from the ability to have private transactions on Ethereum. So unfortunately, you can't donate to us using Tornado Cash today, because if you do, we'll be ordered by the government to freeze that money and not touch it. That's how sanctions work. But there's some other cool privacy tools out there now that are starting to work. So maybe check out Railgun.
Yeah. Awesome. Well, thanks so much. Keep up the good work. I really appreciate it. Thought we got through a lot.
Yeah. Thanks, Gwart. It was a great conversation.